couldn't support it. And that means enforcing our antitrust laws. We know through time, and this is the nature of capitalism, that truly competitive markets can lower prices, give us better choices, and accelerate innovation. That is what has brought us to where we are in terms of innovation. And it's on us as leaders, as our forefathers have done back through history and a few foremothers. But what they have done is that they have fostered that competition by always making sure we're rejuvenating the antitrust laws and making sure they're getting enforced. 4 years ago, Senator Lee and I held a hearing examining what a competition policy for the 21st century should look like. At that hearing, I spoke about cracks in the foundation of our free market economy that stem from a lack of competition. Since then, I have chaired 19 hearings examining competition problems and algorithms and solutions, everything from consolidation in healthcare and the health insurance market to merger enforcement to housing, as well as the emerging issues that we are seeing, the impact of consolidation, as I mentioned, on our supply chain, and with changing technology, what's happening in things like housing rental markets when it comes to what is really high-tech collusion with information and how that affects people. One of the things I was proudest about of our hearings and the work we've done that I believe has made real change, yes, we passed some bills, yes, we've gotten more and more people on board with this, but most importantly, we have continued our role as not just advocates for change, but also for oversight of the agencies. And the work that has been done at the FTC and at the Justice Department. And the hearing that I will most remember is the work that Senator Lee and I did with Live Nation Ticketmaster. It was a very memorable hearing because we couldn't really get many artists to come forward, and the one that came forward, Clyde Lawrence, of the band Lawrence, he was really an effective witness, and both Democrats and Republicans alike was very helpful for them to hear that, in fact, the story of consolidation, how it affects artists. But in any case, during the hearing, I remember this, Mike, because it was one of your great moments. He kept turning around and talking to someone, and people asked me later, because it was televised, the hearing, if that was his lawyer. And I said, no, it was his saxophone player, which it was. And so at one point, a letter was read by a famous star musician by the CEO of Live Nation. And Mike said, well, you know, we are all, Senator Lee said, we're all a fan of that musician. But with all due respect, they're not an expert on vertical mergers. And I saw our witness writing things away, and I'm just like, maybe you want to just stay out of answering this. But it was a very memorable hearing because you literally couldn't tell on what side of the aisle people came from. And it then led not only to some work Mike and I did in pushing forward some ideas, and then Senator Cornyn and I have done a major bill for fans. There's also work going on in the Commerce Committee. But out of that came a major, major investigation, and the evidence that we collected in that hearing, I know, informed the Justice Department's decision about moving forward with their work they are doing on the monopoly of Live Nation Ticketmaster. This committee has also worked across the aisle to introduce and advance significant antitrust reforms, such as my legislation with Senator Grassley to update corporate merger fees for the first time in 20 years, as Senator Grassley would always note. It was signed into law, and it allowed for more resources for the agencies. Before this law went into effect, there were more than 350 fewer employees working at the DOJ Antitrust Division than there were in 1979. We also, at that time, and by the way, there was an actual vote on this and showed the significant support of the Senate on both sides for this, but we also passed legislation led by Ranking Member Lee to ensure state enforcers can keep their enforcement actions in the courts they choose, avoiding wasteful, time-consuming venue transfers and consolidation with private lawsuits. And that was supported by the Republican and Democratic attorney generals across the nation. I continue to work with Senator Grassley on our legislation to stop anti-competitive self-preferencing in our digital markets, with Senators Blumenthal and Blackburn to pass their bill to promote competition in app stores. Very, very important. With Ranking Member Lee on our bill to ensure no online advertising giant can control every side of the ad tech market, of course, a subject of the Justice Department action. Senator Durbin has been also very active in this and in many of the online issues. While these bills have yet, and I emphasize yet, to pass, their contents provide antitrust enforcers a roadmap for remedies on their cases, including the Justice Department's proposed ban on Google self-preferencing its search product in Android. Finally, the Judiciary Committee has passed numerous bipartisan bills, and we thank Senator Durbin and Senator Grassley for his longtime work on this, Senator Cornyn, and as well as Senator Lindsey Graham, to stop the abuses of big pharma that keep affordable generic drugs off the market. It's time these bills become law. Bringing competition issues to the forefront has also resulted in bipartisan consensus that our antitrust laws must be enforced. I had the honor of introducing both Assistant Attorney General Jonathan Kanter. I remember that day well because his son, who was younger, was a big fan of Senator Ossoff and took Senator Ossoff's pencil and Senate drink thing as a souvenir from the event. As senators, this always means a lot when we have like a fan base, or a fan of some kind, which was Senator Ossoff, was the celebrity to Jonathan Kanter's son. And also I introduced FTC Chair Lena Khan in the Commerce Committee and helped shepherd both of them through the Senate with strong bipartisan votes. Khan 69 to 29, but who's counting? Kanter 68 to 29. With this bipartisan mandate, they went on to bring major cases involving Google, Amazon, Apple, Live Nation I mentioned, and many others, groceries, healthcare. Importantly, nearly every single one of these cases and many more, including the FTC's recent successful suit to block the merger of the two major grocery chains, was supported, and this is very key as we go forward and we see a change in administration. It was supported by a strong bipartisan coalition of attorney generals across the country. We don't often think of states like California and Oklahoma pairing up, or Minnesota and Texas, but this has happened in many ways for the support of the work that we have done. Another legacy from the Biden administration was a continuation in a number of vital cases that started under the Trump administration, prevailing in the Google search case earlier this year and readying the Facebook case for trial next year. When you think of successful antitrust efforts that have been positive for the public, like the AT&T breakup, when you look at AT&T is still there, and doing well, but you also have a much better cell phone marketplace and much lower long-distance rates. So that case, that spanned several different administrations, different parties. So the Biden administration didn't simply toss cases brought by the Republicans or settle them for pennies on the dollar. They strengthened them, they won them, and we are hopeful that the incoming Trump administration will do the same thing. I will say, I will be watching. The Biden administration also built on the Trump administration's willingness to litigate the first case challenging a vertical merger in decades. While this case ultimately failed, it paved the way for the Biden FTC and Justice Department to challenge a number of vertical mergers, including unwinding an acquisition that stopped a single company from controlling cutting-edge cancer detection tests and preventing a major chip supplier from acquiring a key chip designer just before the AI boom. We have talked a lot in this past election, if any of you noticed, about bringing down costs and how you can do it, and that is why I just want that to continue. I don't want it just to be talk. I want it to be action in every way possible. And to me, that means we're going to have strong enforcement of our antitrust laws. we are here together to say that this has always spanned politics, and that must continue. I'm looking forward to meeting the new nominee for the Antitrust Justice Department position. I know that there are people on both sides of the aisle who have worked with her and said good things. I'm sure I won't agree with everything she ever does or has said. We always have to say that, you know, when you're in the other party. But I just want to strongly encourage her to continue the work that's going on now. It has been a privilege, I would like to say, just for this committee to work with Jonathan Cantor. He is somehow the happy warrior through having to deal with a lot of hard cases and a lot of difficult senator questions from all of us, and that's part of our job. I also, as a member of the Commerce Committee, have enjoyed working with Lena Khan. And I look forward to the confirmation hearing ahead for the antitrust position. As I prepare to hand the gavel back to Senator Lee, I just meant like that, like a nice way, not like that way. I also, again, want to acknowledge Chair Durbin, Ranking Member Graham, and of course the always present Senator Grassley, who actually texted me this morning about my Christmas card. It was pretty impressive. So I'd like to thank our committee staff for working together so well, and to thank Phil especially, yes, as our whole Ben, Dan, my counsel, our entire team for their work, and I will turn it over to Senator Lee for his opening remarks.
Thanks so much, Madam Chairwoman. I too enjoy working with you, and one regret I have for this Congress is that we didn't take better advantage of the term Klobuchar, which sort of encapsulates all the aspects of the title. There aren't many names that fold right into a chairmanship.
Just when I'm not the chair, you tell me this.
Yeah.
Because just when you are the chair.
Well, no, I used
Okay.
it at the beginning of last Congress. Well.
Okay. Oh, thanks. I forgot.
And I do remember, I think it was the same hearing, or at least a related one, that you were talking about a minute ago. You pointed out very astutely that one of the songwriters, everything he said sounded like a country music song, and it didn't even require alteration. He kept talking about how it just wanted to earn enough money through his songs to be able to take his family out to dinner on a Friday night and to church on Sunday, and it literally sounded like a country song. As the end of this Congress and the end of the Biden administration come to an end, we're I think on the cusp of turning the page on big is bad mantra and rhetoric, and look forward to a new Congress and a new President Trump's second term. Today's hearing gives us an important opportunity to talk about bipartisan enforcement actions and legislative reforms in antitrust policy. And I agree with the chairwoman's assessment that on this committee, these issues normally transcend party. I would love, in fact, to be able to work transcendentalism into the committee title somehow, if we could do that, although it might be even more wordy than it is now. Now, during President Trump's first term in office, both the Department of Justice and the Federal Trade Commission identified some significant harms posed by monopolistic practices and the concentrated power within big tech companies and the impact that those things had on our economy. This led to a comprehensive review of the largest tech platforms, and that review culminated in the filing of some enforcement actions supported by a bipartisan coalition of state attorneys general against Google for illegally monopolizing internet search and advertising, as well as lawsuits against Meta, Apple, and Amazon. These trillion-dollar companies can, if left unrestrained in that regard, not only stifle competition, but also suppress public discourse through ideologically motivated censorship. Enforcement actions against big tech are not only, these are far from the only bipartisan initiatives that we've seen in this area. Antitrust enforcers have increasingly scrutinized the competitive risks posed by, among other things, vertical mergers, the combination of companies operating at different levels of the same supply chain. The Trump administration's challenge to AT&T's acquisition of Time Warner marked a truly pivotal moment in vertical merger enforcement. Although AT&T ultimately prevailed in court, the case highlighted the potential for such mergers to harm competition by restricting access to essential content, potentially slowing industry innovation. The Biden administration has continued this rigorous scrutiny of vertical mergers, exemplified by the FTC's successful challenge to Illumina's acquisition of Grail, which could have stifled innovation in some very critical, pivotal, life-saving cancer detection technologies. In Congress, we've taken significant steps to support federal and state antitrust enforcement offices through recent legislative efforts. And additionally, we're advancing bipartisan legislation to modernize and update our competition policy and address some of the complexities of today's digital economy in ways that are natural extensions and applications of our existing antitrust law. For example, the State Antitrust Enforcement Venue Act, signed into law in December of 22, empowers state attorneys general by exempting their cases from previously existing laws that would have otherwise required them to be consolidated into multi-district litigation. So this challenge enables states to litigate their cases in their preferred venues, enhancing their ability effectively to challenge antitrust violations. And it protects and enhances the state's authority to pursue justice on behalf of the consumers in their states. Additionally, the Merger Filing Fee Modernization Act, also signed into law 2 years ago, updated the filing fee structure for mergers, aligning fees with transaction values and providing increased funding for FTC and DOJ antitrust. By requiring disclosures of subsidies from foreign entities, the law also strengthens oversight of foreign influence in mergers, safeguarding our national interests in additional ways. Last year, I introduced a bill, the bipartisan legislation that I called the America Act, which was co-sponsored by Chairwoman Klobuchar. Google has tied advertisers' access to internet users to the mandatory use of Google's own advertising technology tools. This tying practice forces publishers to adopt Google's advertising technology, leaving digital content creators unreasonably beholden to Google's vice grip over their company's revenue streams, and very often their very existence. Google's conduct has deprived creators of competitive markets, and it really, if left unrestrained, poses a long-term threat to digital content creation. So when one firm acts as buyer, seller, and auctioneer, the entire marketplace becomes subject to that firm's whims, stifling innovation, unless it somehow happens to align with that monopolist's interests at the moment. The America Act promotes competition in digital advertising by introducing some transparency requirements, requirements that I believe would reduce costs for advertisers and, of course, preventing conflicts of interest. Additional legislative reforms include streamlining antitrust enforcement. The One Agency Act would consolidate antitrust authority under the Department of Justice. This would reform the process as a whole by eliminating some inefficiencies, duplication, and inconsistent enforcement standards between the FTC and the DOJ. Because the substantive standards and the processes one has to go through shouldn't vary by the vicissitudes that can turn on something as simple and random as a coin toss. By establishing a single antitrust agency, we'd harmonize enforcement efforts, create a fairer and more level playing field, and ensure predictable, transparent actions with all challenges adjudicated in federal court. In the coming year, with the new Congress and the start of President Trump's second term, we have a chance to champion robust and principled enforcement efforts and to advance essential legislative reforms. Now, these measures will not only reinvigorate antitrust policy, but also unlock innovation, drive sustained economic growth, and protect American consumers. And finally, once again, I want to thank Chairwoman Klobuchar for her dedicated and principled leadership to this committee as its chair. I look forward to continuing our bipartisan work together on this committee. Thanks.
Very good. Senator Grassley.
Yeah, I would like to say a few words. I already spoke to the panel and said I had a 3 o'clock meeting I had to go to, and I'm not here to introduce Professor Newman, former Iowan, but I do want to say a few words about him. I understand that he grew up in Iowa, Hayfield, Iowa, he told me. That's Garner Hayfield High School. Attended Iowa State University, University of Iowa College of Law. I appreciate hearing his views, Professor Newman, in particular your concerns that there hasn't been enough of a focus on agriculture and food supply markets. I agree with you. For years, I've been pursuing our antitrust enforcement agencies to carefully scrutinize agricultural concentration, possibly anti-competitive and monopolistic practices in the agricultural industry. The Senate Judiciary Committee also has convened hearings on meat supply competition, consolidation in seed and agrochemical industry, and grocery store mergers. Ms. Cooley, I know that in your written testimony, you also highlighted agriculture and hope that the antitrust agencies will double down on preventing and reducing consolidation in agriculture. I'm pleased that you both share my concerns. There's a need for more antitrust. I've also been very interested in vigorous antitrust enforcement with respect to other industries. Drug competition, PBMs, high tech are all just some of the areas that I've been focused on. And I think in those areas, Senator Klobuchar's pointed out how we work in a bipartisan way in this committee on that. And I want to say to the chairwoman that we'll continue to work together in this bipartisan way as we have on a lot of issues, I guess. I thank you. I yield the floor.
Well, thank you very much, Senator Grassley, and look forward to working with you, and thank you for bringing up ag consolidation and what an important topic that is going forward. I'd now like to introduce our witnesses. Roger Alford is a law professor from the University of Notre Dame and former Deputy Assistant Attorney General for International Affairs with the DOJ Antitrust Division. Thank you. John Newman is a law professor at the University of Miami, focusing on antitrust and competition. He formerly served as the Deputy Director of the Bureau of Competition within the Federal Trade Commission. Gwendolyn Cooley is the former chair of the National Association of Attorney Generals Multi-State Antitrust Task Force and served as an Assistant Attorney General for Antitrust for the state of Wisconsin from 2005 to 2024. That's a long run, almost as long as Mike and me doing this committee, under Republican and Democratic Attorneys General. So thank you for that. And now we're going to swear witnesses in. It is a tradition of this subcommittee to do that. So please stand up, raise your right hand. Do you swear that the testimony you will give before the subcommittee shall be the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you. You could be seated, and we'll begin with Professor Alford.
Chairman Klobuchar, Ranking Member Lee, thank you for inviting me here to be a witness here on the future of antitrust law in the coming administration. As you said, I'm a professor of law at Notre Dame Law School. I have my Notre Dame colors on. I'm very excited that Notre Dame is in the playoffs. I'm not excited that I spent $75 in Ticketmaster fees for a $150 ticket. Yeah. I also served, as you said, as Deputy Assistant Attorney General in the Department of Justice. For the past few months, we have had a national debate on the merits of economic populism. It may be fashionable in elite circles on the left and on the right to deny, discount, or discredit these impulses, but they are real and they have had dramatic political consequences. As an emerging party of the working class, Republicans are moving away from orthodoxies that reflexively support big business and toward an open discussion about tariffs, unions, and antitrust. The Republican term for this is common sense economic populism. Such populism is wary of the abuse of power in the hands of the government or business. It embraces free markets and competition on the merits. It is skeptical of government intervention in the markets, but it is also skeptical of corporate power, especially the kind that colludes with the government to harm consumers through the passage of anti-competitive regulations or, as we've seen recently, the blocking of pro-competitive regulations. FTC nominee Mark Meader recently posted a meme in which libertarians are skeptical of tyranny.gov, but not tyranny.com. Economic populists share no such confusion. How will economic populists govern? The new leadership in the Trump administration will make good on the promises of common sense economic populism. This approach will be neither Bork nor Brandeis, but pursue its own path of economic freedom from the abuse of political and corporate power. In terms of priorities, one should expect that the new administration will focus on markets that most directly impact the cost of living of the average American. Consumers spend 88% of their expenditures on just 6 major categories: housing, transportation, food, insurance, healthcare, and entertainment. The Biden administration focused on many of these core industries, and the Trump administration will continue along a similar path. In terms of intensity, one can expect that the new administration will vigorously enforce the antitrust laws, recognizing the fallacy that markets self-correct. They know that barriers to entry are real, that network effects are common, that markets are prone to tipping and consumer lock-in. Under-enforcement ignores the durability of market failure and the harm that such failure causes. Anyone who is faithful to the text and history of the antitrust laws must be skeptical of Robert Bork's agenda promoting under-enforcement. With the incoming leadership of Gail Slater and Andrew Ferguson, we should assume a rebuttable presumption that the antitrust cases filed by the Biden administration will be pursued by the Trump administration. It will do so relying on a broad understanding of the consumer welfare standard that includes price, output, quality, innovation, or anything else that impacts consumer demand. To the extent it changes course, it will do so only where the Biden administration has pursued novel enforcement theories with difficult facts that have failed in court. The most notable point of bipartisan consensus that's already been mentioned today is vigorous enforcement of antitrust laws to address big tech monopoly abuses. Both President Trump and Vice President-elect Vance share strong skepticism toward big tech, with Trump describing big tech as running wild for years, and Vance stating, "I think you have to break these companies up. They have become monopolists." The nominees to head the DOJ and the FTC also share these concerns. Congress can have a constructive role in addressing big tech monopolies. It can pass pro-competitive legislation that was just mentioned, like the America Act or the American Innovation and Choice Online Act. Such legislation could have passed in 2022, but for over $250 million that was spent by big tech lobbyists to block such measures from even coming to the floor after supermajority votes out of committee. It also could hold hearings on potential big tech remedies in the pending litigation and the unethical manner in which they have defended their monopoly abuse. On mergers, the incoming Trump administration will challenge anti-competitive horizontal and vertical mergers. That approach was taken in the first Trump administration and to an even greater extent in the Biden administration. What likely will change is a reversal of the general skepticism toward mergers and acquisitions. Consent decrees, for example, were strongly disfavored. In the Biden administration, the reasoning was that simple injunctions are easier to enforce than complex settlements. That is true, though, of course, only if you win. Such an approach has undermined the possibility of reasonable settlements. Innovators have expressed widespread frustration with the Biden administration's hostility toward startup acquisitions, and I think this may be the point of largest difference between the two administrations. The Trump administration will balance hostility toward big tech with sympathy toward innovators and startups. If startups cannot exit, they will not be funded. Last year had the lowest exit activity for startups in a decade, and the government hostility is perceived by them to be part of the problem. And that may change soon. Thank you, and I look forward to your questions.
Very interesting. Thank you very much, Professor, and thanks for your long time work. Appreciate it. Professor Newman.
Thank you, Chair Klobuchar and Ranking Member Lee, for the opportunity to appear before you today. As Senator Grassley pointed out, I grew up in Iowa, and I attended the University of Iowa College of Law. After graduating, I joined the U.S. Department of Justice Antitrust Division as a trial attorney, and antitrust has been my professional life's work ever since. Today, I'd like to talk about four areas of new antitrust consensus that I think crosses party lines. I want to be clear that I don't think these are the only four areas, but I do think there are four especially important ones. The first is understanding the serious harms that can occur in zero-price markets. For a long time, our antitrust community had a blind spot. Markets without prices didn't seem to be markets at all and were therefore unworthy of our protection. The first signal of a new approach here actually came in 2019 when then Assistant Attorney General Macon Delrahim began sounding the alarm about under-enforcement in these markets, and a salvo of groundbreaking lawsuits, both by federal enforcers and state counterparts, against Google and Facebook followed in 2020. Now, these zero-price markets, they do lack prices, but these bipartisan efforts recognize that harm from monopolistic conduct in these markets, harms like excessive advertising loads, degraded privacy, or an overly concentrated marketplace of ideas can be massive. Now, those cases had another thing in common. Besides involving zero-price markets, there were also big cases against big tech firms. They weren't narrowly limited to a particular instance or type of conduct. And that's important because it can, among other things, help a judge craft an appropriate, effective, and fully effective remedy. Now, winning a big, worthwhile Sherman Act case these days is not easy. In fact, the original FTC complaint that was filed against Facebook in 2020 was dismissed. But instead of abandoning that complaint, as previous new leaders have occasionally done before, one of the first things Chair Khan did was to dust off that complaint, strengthen it, refile it, and this time it survived a motion to dismiss. That case is headed to a trial. DOJ's complaints against big tech firms like Apple and against Google's ad tech practices and structure really continue this big tech, big case tradition that began under President Trump and, if anything, accelerated under President Biden. I would include in that group the FTC's case against Amazon. That was yet another big case that was joined by a big group of bipartisan states. Now, many of these cases involved so-called vertical restraints. For a long time, those were not high on our list of things to go after, but that economic thinking has changed. Restraints imposed by dominant firms on suppliers or customers can be quite harmful. And as we start to look ahead, I think it's worth noting that vertical restraints imposed on labor markets, which economists are now finding to be perhaps surprisingly uncompetitive many times, are an area where future antitrust efforts could have a big, important impact. Speaking of vertical conduct, another area where there's a new bipartisan consensus is around litigating to block vertical mergers. The agencies have filed a number of cases, I think, building on the first foray, AT&T Time Warner in 2017, that challenge vertical mergers and try to block them. All those efforts haven't been successful, but a number have, and I think when you're trying to achieve a new enforcement priority like this one, having the track record the agencies have in such a short amount of time is actually really remarkable. Another area, and this is an area that's near and dear to my heart as someone who grew up in Iowa, is the importance of agriculture and food supply markets. In high school, one of my first paying jobs was working for a small, and at the time it was actually the smallest in the country, independent soybean research company. And I drove very small tractors and I drove very small combines. And we researched soybean genetics. It was a company founded by a local farmer. Today, that company doesn't exist anymore. It was bought up by one of the giants. And the town where I grew up, the town where I went to middle school and to high school, that town is slowly dying, frankly. Concentrated corporate power is not the only reason for that, but it is one of the reasons. And I joined the Antitrust Division's Transportation, Energy, and Agriculture section specifically after graduating from law school to try to do something about what I had seen. And the leadership at the time had been saying some really encouraging things about antitrust enforcement in agriculture markets, but that turned out to be, at the time, mostly just talk. Now, you fast forward to 2022, the FTC and a group of state enforcers, including my home state of Iowa, filed a big, important case trying to protect farmers against a couple of chemical giants that were depriving farmers of low-cost inputs. Both the FTC and the DOJ have also taken action to keep food costs down for consumers. The Antitrust Division sued a company called AgriStats for driving up and allowing big meat processors to drive up costs of meat for American consumers. The FTC, for its part, along with another bipartisan group of states, just successfully blocked the Kroger-Albertsons mega merger that would have driven up food prices for American consumers and driven down wages for American workers. Now, all that being said, I do think a lot of work still remains to be done in these areas. So looking ahead, that's why I am especially excited about this new consensus we're here to talk about today.
Very good. Thank you. Excellent testimony. And next up, Ms. Cooley. Thank you so much.
Thank you, Senator. For over 100 years, attorneys general around the country have united to tackle consolidation. In my nearly 20 years' experience as a frontline antitrust enforcer, working with both Republican and Democratic attorneys general, I have seen firsthand, on the ground, how effective antitrust enforcement can be when we embrace our diversity of opinions and tackle consolidation and anti-competitive conduct head-on together. One note before I begin, my testimony is mine alone, and I do not speak for the state attorneys general nor the federal antitrust agencies. So first, a bit of background. State antitrust enforcement is often called the third leg of the antitrust enforcement stool. And state attorneys general enforce the Sherman and Clayton Acts, as well as their own state antitrust laws, some of which, like Iowa's, which seems to be the state of the hearing, predate the Sherman Act. Indeed, many state constitutions, like Tennessee's, treated monopolies with contempt from the outset. The earliest challenges to monopolistic practices were brought by state attorneys general who learned early on the virtues of many hands making light work and bipartisanship, which became the foundation of the National Association of Attorneys General in 1907. My former role as chair of the Multi-State Antitrust Task Force involved helping states work together in a process very similar to this august body, through negotiation and discussion to achieve the best results for the citizens of our states. In fact, I often compared myself to Senators Schumer and McConnell. Besides our obvious resemblance, when leading cases, I would cajole, discuss, and bear witness to my sister states' complaints. We often take for granted how difficult this kind of multi-state consensus can be, as the attorneys general have, to put it mildly, widely varying views. Even more importantly, they're also separate sovereigns. But because of our differences, the states' relationship with each other has remained tremendously strong. For 8 long years, I led the states in a lawsuit against the makers of Suboxone, where 42 states sued to ensure that the market for this important opioid treatment drug was not monopolized by one company. It was crucial when we ultimately settled that case for $102.5 million in the summer of 2023 that we had such diversity of viewpoints to ensure that we were jury trial ready and didn't have to settle for less. That consensus was not easy, but it speaks to the general view that bipartisanship is the name of the game in antitrust. And while it's difficult, it's always worth it, and not for touchy-feely reasons, but because one of the secretly genius aspects of having mixed groups of states work together is that we genuinely do not agree. And so when Minnesota and Utah and North Carolina and Hawaii battle, with Arkansas, Delaware, Rhode Island weighing in, by the time consensus is formed, the work product has been thoroughly vetted. And while it can be clunky and slow and exhausting for participants, a feeling that I suspect this committee might relate to, not having a decider results in cases that are more provable and persuasive to judges. Often folks like to simplify this to red states and blue states, but frankly, this shorthand is essentially meaningless as these cases go before judges. And I have personally won and lost cases before federal judges nominated by presidents of both parties and have not found party of appointing president to be determinative, which is probably the point of an unbiased judiciary. But it is not in pharmaceuticals and only where state bipartisanship and our strong relationship with the federal government has played a crucial role in antitrust enforcement. We've talked a little bit about agriculture, and I think that is a quintessence of a partisan issue. In my experience working as a very junior staffer for the US Senate many, many years ago, I would say it's a much more regional issue. And nowadays, with the help of a grant from the United States Department of Agriculture, state attorneys general have been working with their federal counterparts to ensure that we have safe and redundant food supply by ensuring that each step in the supply chain is competing by being the best rather than through monopolistic practices. It's my hope that in the next administration, we do see our antitrust agencies, as Senator Grassley pointed out, double down on reducing consolidation in agriculture, from meat packing to dairy, and from seeds to pesticides. And of course, it is not only the agencies that have done great work. This committee has done great work, bipartisan work on antitrust, and the State Antitrust Enforcement Venue Act, which we in the state world call SAVA, is a great example of how this committee has made a sea change in the way we prosecute these cases. Senator Lee's SAVA bill originally was promoted by attorneys general who came together under Texas's leadership to protest the removal of the Texas v. Google case from Texas to New York. Justifiably irritated with having to face a New York judge, Attorney General Paxton rallied his colleagues across the political spectrum and across the country and ultimately succeeded in having 52 attorneys general of 56 write a letter to Congress to protest defendants' ability to force state AGs to litigate their cases wherever defendants decide. Thank you for passing that bill in 2022. Your work on that statute has proved invaluable. The Google AdTech Texas case moved for a change of venue, which was granted. The DOJ AdTech case stayed put in Virginia. And the long-running state's generic drugs price-fixing case finally had a breakthrough when it returned to Connecticut, where it was filed. And so, again, while I don't speak on behalf of the attorneys general, I feel comfortable that they would not object to me saying, thank you so much. We needed SAVA for litigation against big tech, which we have focused on for years. And as past counsel for the state of Wisconsin on many of the big tech cases, if not all of them, there's only so much I can say about them. But I can say it's remarkable. We've talked about before how these cases were brought by huge groups of attorneys general and the federal government. But I will note, 5 cases against Google, with Google search having a combined 52 attorneys general litigating with the US Department of Justice, Facebook, Amazon, and Apple, all filed by large groups of bipartisan states. And the Apple case is led by New Jersey, if Senator Booker just wants to give them a shout out. So with continued diligence in agriculture and against big tech, and a strong working relationship with the state AGs who have long embraced the virtues of bipartisanship, I believe antitrust enforcement efforts will be stronger than ever.
Well, thank you. Thank you, all of you. Really thoughtful testimony that's going to help us to get through the next few months into a new administration and really remember what's grounding us in these cases. I guess I'll start with you, Ms. Cooley. You talk about the bipartisan coalitions and what interesting bedfellows they are. As I noted as well, they have starkly different worldviews on a lot of things, but they're standing up for competitive markets in their states. Can you talk about how cases brought with bipartisan coalitions of state attorneys general help to improve antitrust enforcement actions? Certainly it helps us on the legislative front here, and certainly it helps when the cases are filed, but just talk about a little bit from your perspective, because it's the attorney generals that have kept doing the pushing of this while administrations change. That has been a constant for a very long time. Talk about that.
Yes, sure. So bipartisanship is so important. I mean, it helps us plead stronger cases. We make sure that when we are establishing the legal foundations for the case, we have fewer outrageous claims, fewer claims that are less palatable to a broad variety of attorneys general. It's things you wouldn't think about, like witnesses. Certainly, if you are bringing a case in, for example, Connecticut, you want to make sure that you have people who would understand what it's like to be on the jury in Connecticut, right? So you want to make sure that you've got good bipartisan and broad support there. Settlements, honestly, having states that are not going to just go along to get along because they want to support their sister states of the same party and are happy to stick it to them, it's great.
Okay.
It makes
Good. Thank you. We've just had Senator Blumenthal arrive. We're very excited about that. I mentioned him when he wasn't here. So anyway, I'm going to get through my question.
About trying cases in Connecticut.
Yes, this was mentioned as well. So I'm going to finish up my time and go to Senator Lee, then we'll go to Senator Blumenthal. So Professor Newman, one of the bipartisan reforms that we mentioned, addressed, was the bill I had with Senator Grassley, the Merger Filing Fees Modernization Act. From your time at the FTC, can you tell us a bit about how resource constraints affect enforcement decisions, how additional resources can make a difference, actually bring money in?
Yes, absolutely. And first, if I could, I'd like to thank you for your work on that. It was a shot in the arm for a couple of agencies that had been, underfunded, I think, relative to the overall growth of the U.S. economy for a fair amount of time. Let me say at the outset that the agencies do an amazing job with what they are given, but they can only do so much. And so when you see something like a spike in merger activity, the agencies go into triage mode. They have to. You would be neglecting your duties if you didn't review all those mergers. So the workload can skyrocket, as it did in 2020, 2021. If the agencies aren't effectively funded, those people reviewing those mergers are going to have to come from somewhere. And when they start looking around and see these big tech cases, I think that could be an attractive place for them to start moving people away to just try to deal with all these mergers. So the structure of the bill, I think, makes a lot of sense to me as a former enforcer, that it would increase fees as merger filings go up. All that being said, I think at the end of the day, these cases are big, they're hard. The agencies do a lot with what they're given, but I'm not sure they're there yet.
Right. Well, they are outmatched all the time, and the companies know that. So, but they valiantly moved ahead. And I think part of this bipartisan support matters because they know they have people on their side, the agencies do, that stand up for them. So thank you. Professor Alford, last, the Trump administration challenged two mergers in the health insurance market: Anthem's acquisition of Cigna and Aetna's acquisition of Humana. The Biden administration has continued to prevent consolidation in healthcare markets, including the recent DOJ suit to block United Health's acquisition of a home healthcare provider. Why is it so important to continue strong enforcement in health markets?
So, as I said in my written testimony, health markets are one of the most important areas in which consumers are impacted in terms of cost. The cost of healthcare in the United States is dramatically higher than it is in almost every other country, and it is a huge percentage of the budget of the average American. The lack of competition that happens in the healthcare industry is, quite frankly, remarkable. In addition to the comments that you made, there's also the recent litigation against PBMs. That's a huge additional area of significant concern. And I think there's a general sense that the healthcare markets are broken in terms of the way competition functions, and this kind of litigation is essential for the markets to be corrected.
Thank you. It's Senator Lee and I held a hearing this fall that focused a lot on healthcare consolidation. So thanks for that answer. Senator Lee.
Thanks so much. Professor Alford, I want to start with you. As you recall, the Department of Justice and state attorneys general sued Google over its alleged abuse of monopoly power in the advertising technology market. There are those who look at that and say that shows that our current antitrust laws are sufficient and no need to adjust anything based on modern technologies and how modern technologies might be being abused because this action has been brought. So I was wondering if you could discuss how reform measures like the America Act could address competition in, for example, the advertising technology market as part of the solution, in addition to the pending litigation.
So, as a conservative, I know you have the same viewpoint. Generally, we prefer litigation over regulation, but there are instances in which litigation is simply not sufficient And this is one of those areas where the litigation against Google is focused on a very, very narrow category of misconduct by Google in a very specific market, and yet Google is a monopoly, as Senator Hawley has said, in multiple different markets. And
Did you just say that because you walked in? That was pretty impressive.
Thank you. I just pivoted there, yeah.
He had that in his remarks already.
Exactly. Take YouTube, for example. There's nothing in the case at all about YouTube, probably because the market definition is unclear and getting over the 60% threshold that you would need is difficult, and therefore both the DOJ and the 17 state AGs didn't even include YouTube in the discussion, and yet your legislation would directly address the same exact conduct in the video advertising market. I also would credit you for the legislation for a whole other reason, which is in the event that the DOJ is successful in the coming weeks in the ad tech case, which I hopeful that they will use your legislation as a model for the kinds of remedies that may be appropriate. So it actually signals what should be happening with respect to remedies.
Great. Now, drawing on your expertise, your time serving as Deputy Assistant Attorney General in DOJ antitrust, how, in your opinion, would the One Agency Act eliminate inefficiency and enhance our antitrust enforcement efforts in this country?
So as I said in my written testimony, the major concern from my perspective about having dual agencies is we know it can be done successfully because that's the way it's done in every other country in the world. We're really the only major competition authority that has two agencies. So we know it can be done, right, with one agency. The biggest inefficiencies, I think, as I said in my testimony in writing, is the clearance and conflict issues that come up. They come up in very small ways on specific merger reviews, and the discussions often during the 30-day window that you have for second requests, often several of those days, numerous days, are just about clearance before you actually review it on the merits. But more importantly are the big macro questions, like who should take leadership over artificial intelligence? Both, even though the relationship between Lina Khan and Jonathan Cantor is wonderful, they both strongly wanted to take leadership on artificial intelligence, and they've had many, many conversations about that. In the Trump administration, we had months and months of discussions about big tech and who's going to lead at the FTC side. So that takes a lot of effort to try to just resolve those sorts of issues on the macro level.
Especially given that in many markets, especially many of the newer markets, it doesn't fit neatly into things that one agency or the other has followed. It's sort of neither man nor horse, but like the centaur, pieces of both.
Like vertical mergers, the Amazon purchasing Whole Foods, I mean, you have different agencies traditionally doing different things. It seems odd that you would have one agency taking beer and another taking hard liquor. I mean, there's a lot of oddities that happen with the clearance arrangement.
Right. Usually you don't see that outside of a state alcoholic beverage commission.
Well, we did have a good hearing on beer.
Yeah,
Beer
that's true.
hemoth.
That's true.
Yeah, okay.
She wanted to have samples.
Okay,
And,
said no. What?
and I would have been fine with the samples, just, well, unless they had the non-alcoholic stuff, I wouldn't. I assume the real thing must taste a lot better than the non-alcoholic stuff, because that's not very tasty. Professor Newman, you touched on zero-price markets in your opening testimony. How do you think, what do you think is the best way to contextualize zero-price markets and how to understand them in the context of the consumer welfare standard? There are those who would take that to its logical conclusion and take Bork's words decades ago and say that means the consumer welfare standard has just would leave zero price markets alone. Tell me your view.
So I think that a lot of the harms that we see from a lack of competition in zero price markets actually are surprisingly very analogous to the more familiar types of monopoly overcharges we've long seen in positive price markets. It just requires us to really wrap our minds around the fact that even though there's no price tag attached, we are paying for these things, right? We quite literally pay attention when we use these things. We pay attention to ads. We pay by surrendering our privacy. And if a monopolist doesn't face enough competition to keep our costs low, our attention costs or our privacy costs low, then you're going to see a monopoly overcharge, just like you would with a positive price market.
So in that respect, the consumer welfare standard applies on all fours within zero price markets. If there is no overt price with a price tag that you can see, you are the product, to phrase it differently, you are paying, you're just paying in a different form, paying with your time, your eyeballs, your mouse clicks, your data. And that too can and does, it's fairly easy, in fact, to translate to a dollar value. And so you would agree then that that does have a price, and because it has a price, it's not accurate to say that zero-price markets are somehow existing outside of the universe of the consumer welfare standard.
I think that's exactly right. And I would go maybe even a step further and say, you know, we're used to thinking of money as being a very valuable thing, but what's more valuable than time, our attention, our privacy, our information about ourselves? So, yeah, these are familiar harms in a sense, but they're really serious ones.
Right. Perhaps law professors who sometimes practice in antitrust should be able to calculate their billable hour rate into that, but we'll leave that for another hearing. Thank you, Madam Chair.
Thank you very much, Senator Lee. Senator Blumenthal.
Thanks, Madam Chairman. First of all, thank you and Ranking Member Lee for the last 2 years of really remarkable leadership on this panel. We've had tremendously valuable hearings and a lot of insight, and I'm hoping that we will all continue working together in a very bipartisan way, as we have done on many of these issues. Ms. Cooley, thank you for all your great work. I was Attorney General until about 2010. You were overlapping during part of that time, and some of the most productive and valuable work done by Attorney General offices is in the antitrust area, and you've been a leader. Your office has worked cooperatively with Connecticut, so thank you for all you've done. How would you assess the general work now of Attorney General offices? Are they continuing to be a vital force in antitrust enforcement?
I think absolutely. We're seeing a revolution of attention to state antitrust enforcement, not only in state attorney general's office, but also in state legislatures. We're seeing state AG shops expand in antitrust. We're seeing funding for these groups in bipartisan fashion. We see it in Minnesota, we see it in Tennessee, we've seen it in Indiana and Utah and other states. So yeah, I think it's really improving.
It is really important for the public to understand that state enforcers can do antitrust cases. We have that power to enforce federal law, and the appetite for antitrust varies at the federal level from administration to administration, whether it's Republican or Democrat, but state enforcers can be a constant there. So I think that's very important. Mr. Newman, you make, I think, a very important point about the zero price markets issue. And I ran into this issue when I led the states, a coalition of states, in an antitrust action against Microsoft. And I was very proud. I was really enthusiastic, and we brought the lawsuit. We filed it in Washington, D.C. We enlisted the antitrust division to come along with us. I went home, and people were saying to me, "Why did you sue Microsoft? It's free. You know, why are you threatening this company that charges us nothing?" And I think it's very hard to convey how antitrust can have an impact, or more precisely, lack of competition can have an impact in denying access to markets, in squelching innovation, all the negatives that can result. And we know, for example, that that Google and Apple now dominate the mobile markets. I don't have time, and I don't know that there's interest for me to go into a long description of why that's bad, but I do think that our antitrust laws have an application there for the benefit of consumers. And last session of Congress, Senator Blackburn and I introduced the Open App Markets Act, which would set fair, clear, enforceable rules to protect competition and strengthen consumer protections within the mobile marketplace, where right now Google and Apple have such a stranglehold. We're going to introduce that measure again, the Open App Markets Act, which would set rules also to open new competition for alternative markets like interoperability requirements and opportunities for app developers to offer lower prices to consumers. By the way, the measure was very bipartisan. In addition to Senator Blackburn, it was co-sponsored by Senators Graham, Durbin, Senator Klobuchar, and other members of this committee. My question for you is, do you share the assessment about what role upfront rules like the Open App Markets Act or Senator Lee's America Act could play in restoring more vibrant competition and consumer protections in digital markets?
Well, yes, I think absolutely legislation has an important role to play here. Antitrust law enforcement is a really powerful tool, but it is law enforcement. As such, it tends to be slow. It tends to involve a single case. And when you've got something like an app ecosystem, the significance of all the conduct on all the developers for the American people, I think demands, in this case, a pretty broad approach. And just to take one example, one of the things that jumps out to me from the bill is the requirement that a powerful app store operator can't prevent a developer from truthfully communicating price information to their own users. I think that's a no-nonsense, just slam dunk, right? I think there are some other things in the bill that I think would do some good as well. But yeah, I think there's just a lot in there that could solve some serious problems here.
Thank you. I'm out of time, but I look forward to continuing this work in the upcoming session and working with all of you and our leaders. Thank you.
Senator Hawley, thanks for being here.
Thank you. Thank you, Madam Chair. Thanks to Senator Lee for calling this hearing. Thanks to the witnesses. Professor Newman, let me ask you just a question or two about Amazon. You're aware of Amazon's use of independent contractors, I bet. Is that fair to say?
Yes, that's fair.
Amazon calls their delivery service partner program, or they should say they call their independent contractors their delivery service partner program, or DSPs. Does that sound? Are you familiar with this, broadly speaking?
Yes.
So these, as I understand it, this delivery service program employs about 300,000 people, and according to Amazon, none of these 300,000 people, their delivery service partners, so-called, actually work for Amazon, which is convenient because in reality, Amazon exercises enormous control over these delivery service partners. They control their contracts. They control every aspect of their business. They tell these partners, these independent contractors, which vendors to use, which routes to follow, you name it. They even monitor the performance of individual drivers. And in some cases, Amazon, unilaterally fire the driver. So my question is, does that really sound like, and your understanding of the law, does that really sound like a classic independent contractor? If the parent company is exercising that degree of control over the vendors, over the individual drivers, does that sound like a truly independent relationship to you?
Well, not being a labor law expert, I'll give you my antitrust opinion. That
Good.
does not sound like a traditional relationship. No.
Yeah, it doesn't sound like it to me either, but it does sound convenient for Amazon in a couple of respects. I mean, first, it means that if these are all independent contractors, they don't, legally speaking, they don't work for Amazon, then that means that they can't organize for work and working conditions and better wages. Is that right?
I think that's right.
Yeah. So it's a great setup for Amazon. It's less clear to me why it's such a great setup for their non-employees, but the folks who aren't technically Amazon employees, but yet just happen to work every single waking hour just about for the company. Does anybody else want to weigh in on this, Ms. Cooley? Do you have any views?
I'm similarly not a labor lawyer, but yes, I I can see why that would be concerning.
Don't you think that it also gives Amazon an advantage over other companies like UPS? I mean, UPS employs their drivers. They have to be responsive to their drivers. They have to negotiate with them. By treating them as so-called independent contractors, Amazon doesn't have to do any of that for any of their drivers, right? I mean,
So certainly having vertical integration can have anti-competitive effects.
let me ask you, while I've got you all here, just on a different subject, just on the subject of healthcare for a second, and pharmacy benefit managers, and speaking about vertical integration. Why is it that insurance companies, why should health insurance companies be able to buy up the PBMs and also buy up the pharmacies, so that the PBM, as I understand it, is supposed to negotiate with the insurer and with the pharmaceutical companies in order to get better prices? But if the insurance company owns the PBM and they own the pharmacies, and in some cases they own the doctor's practices, I mean, who's really benefiting? Is that a good thing for patients? Do any of you think? I mean, is that degree of vertical integration, is that a positive thing?
No, it's definitely not. I mean, I welcome the recent investigation litigation against PBMs. We need more such investigations about their misconduct. I don't think that the price negotiations are even genuine. You think about all of the people that are uninsured and the price that they're supposed to pay, and then the price that is quote unquote negotiated is basically, I wouldn't say fraudulent, but basically not truly a representative of what the two prices are.
Yeah, thank you for that, Professor Alford. I mean, that states my concerns very aptly. And it just seems to me that from a competition standpoint, if we are allowing this degree of integration in the healthcare market, if the insurance companies can own the PBMs, can own the pharmacies, can own the doctor's practices, in some cases now can own the hospitals, I mean, the only person who seems to benefit from that arrangement is the insurer. It's the vertical integrator. The people who really seem to lose out are the patients, who no longer have any meaningful choice anywhere. There are no cost savings passed on to them because one entity owns all of it, owns the entire chain, and I think we're seeing more and more of that in American healthcare, and this is why, as recent reports have indicated, not only is healthcare more expensive than ever in this country, year on year, health insurance, I mean, it's just totally unaffordable, but access to care is actually declining. So the services provided are getting worse, and you can talk to doctors, you can talk to independent pharmacists, they hate it, and they feel squeezed. And it seems to me the only people who are really doing great in this are the big-time insurance companies and the PBMs that they own. I mean, you want to add something, Professor Grant?
It is useful that there's been recent legislation that has basically removed the insurance immunity from antitrust laws. And so now, all of a sudden, we're seeing the repercussions of that, and we should see more investigations against insurance companies, including health insurance.
Yeah, that's terrific. And I'd like to go further. I've introduced bipartisan legislation with Senator Warren that would prevent this sort of vertical integration by insurers, PBMs, pharmacies. I think we've just got to say that this has got to stop. It is highly detrimental to patients, to cost, and to the quality of care. Thank you, Madam Chair.
Thank you very much. I'll start again with you, Ms. Cooley. In 2021, a bipartisan coalition of 32 state attorneys general sent a letter to Congress recognizing a lack of competition in important sectors like tech and supporting our work to modernize our antitrust laws. That's when I spoke in my opening about rejuvenating our antitrust laws. You have to kind of make some changes with the time when court cases make it incredibly difficult to bring these cases, or when it is crying out because a new sector of the economy has grown and there's nothing that really gets at that. It's time to make some changes to our law. And that included this letter, support for the legislation I mentioned previously with Senator Grassley, the American Innovation and Choice Online Act. How would modernizing the antitrust laws help state AGs to better protect consumers and boost competition in their states?
I think it would be an incredible benefit to states to have a statute like that passed. Because right now, when we are doing litigation, we are always on the back foot. Now, I know that it's not particularly popular to talk about what's going on in Europe, but Europe is able to get, especially through the DMA, they are able to get concessions from big tech companies because they have the DMA that we then have to litigate extensively, expensively for years to get the same kind of things like a choice screen or to make sure that you have a choice of providers in your scheduling for a video call.
Very good. Thank you. Professor Alford, last year I held a hearing with Senator Lee evaluating vertical merger enforcement. While some vertical mergers can result in efficiencies, others harm consumers. While you were serving at the DOJ, the Trump administration brought the first litigated case challenging a vertical merger in 40 years. Why is it so important for the agencies to closely scrutinize vertical mergers and be willing to challenge those that violate the law?
Yes, as you said, we've had a sea change on vertical mergers since 2018, and all of a sudden we recognize that they can pose a significant risk to the markets. The most important two risks, of course, are foreclosure and raising rivals' costs. And the vertical merger scenarios that are, I think, most problematic is when there is content that a competitor wants. That's what was going on with AT&T and Time Warner. And they will try to foreclose access to that content by the competitor. In the AT&T Time Warner merger, I think it's underappreciated that the AT&T litigation strategy was to make promises after the expert opinions multi-million-dollar report was written, and they offered an irrevocable arbitration commitment to not have blackouts. And therefore, our expert report wasn't able to factor that in. That was a very, very problematic situation because basically they were making promises about how they're going to run the market in the middle of litigation. And that created a huge problem. I think we would have had much greater success in that case had that been disclosed earlier.
Okay. Professor Newman, while you were the deputy director at the FTC's Bureau of Competition, the FTC prevailed in multiple challenges to vertical mergers, including one victory key to ensuring competition in certain cancer detection tests that I mentioned earlier. Can you provide a few examples of cases that the FTC brought that successfully blocked these types of mergers and how these actions have helped consumers?
Yes, absolutely. That's a great one to start with, the Illumina Grail merger. The FTC was able to successfully litigate that one, and the companies walked away. And if you listen to the skeptics, I think you might have thought, oh, these companies are going to immediately stumble, they're going to die on the vine. What we've seen is the opposite. You know, they continue to thrive. The target firm there, Grail's stock price just hit an all-time high. So they're doing really well. Illumina's doing just fine. And maybe even more importantly, we've seen the other players in the market. Professor Alford talked about one of the threats from a vertical merger being the upstream company can shut off access to its important input. That's what the FTC was worried about here. The merger's been blocked, so now the upstream company has no incentive to shut off access to any one player. And we've seen a number of players downstream who are currently racing to develop these multi-cancer early detection tests succeed.
Very good. Also, while serving in the Justice Department in the Trump administration, Assistant Attorney General Macon Delrahim expressed concerns about the efficacy of complex settlements imposing hard-to-enforce rules and restrictions on companies, and spoke in favor of structural remedies like breakups and divestitures. Professor Newman, can you talk about the types of cases that you think are most appropriate for structural remedies? And I guess I'll ask the same thing of you, Professor Alford, about when these can be most effective. Professor Newman.
Well, I think when it comes to horizontal mergers, it's hard to think of a better remedy than a structural remedy. When it comes to a lot of vertical mergers, a structural remedy offers a lot of advantages over a behavioral play nice remedy. Beyond that, I think it really has to be done on a case-by-case basis. And I would say the same thing about monopolization cases. It's got to be case-by-case.
And I was separating this from a question on vertical mergers. And Professor Alford, I guess, as well as talking about when it's appropriate, do you expect the incoming administration to continue to focus, as Macon Delrahim had mentioned in the past Trump administration, on structural remedies as a potential result?
Yes, I think they definitely will. The example that I would give of the difficulty of behavioral remedies is Ticketmaster Live Nation. I mean, it's just incredible the various promises that were made about the way that they would
maybe even in this very room.
Maybe in this very room, exactly. And we had a consent decree in the Obama administration. We had a renewal of that consent decree in the Trump administration. And finally, there was a recognition this is never going to work that way. We need to sue them, and that's what happened in the Biden administration. So yes, I think that is the kind of thing that will be a similar sentiment in the coming administration.
Okay. question.
Professor Alford, some international jurisdictions have moved more in the direction of a regulatory scheme as opposed to a law enforcement scheme like what we've got here. Now, this has become very common in Europe, and I suppose it works well for what Europe's competition laws appear to want to protect, which is competitors as opposed to competition and consumers. In the United States, we've taken a different approach with law enforcement, and I hope that we will stick with that, because I think the regulatory approach has a number of problems, not the least of which is this dynamic. I think the arc bends toward incumbent protection and protectionism generally if we move toward a regulatory structure. First of all, I'd love to get your thoughts on that, whether you agree with it, and your thoughts on how the United States can lead through our pattern of enforcement on the world stage.
Yeah, I do agree with that. In fact, I said the exact same thing last month in testimony regarding the credit card industry. As a conservative antitrust enforcer, you generally try to prefer litigation over regulation, but there are situations when regulation is appropriate. It is incumbent upon the FTC and the DOJ to vigorously enforce antitrust laws so that we don't need to go to regulation whenever possible. The problem with regulation is it sometimes just paints with a broad brush and deals with issues that are anticipated but maybe not are going to be evident. That's true with the European recent regulations on artificial intelligence. We don't know where our AI is going to go, and there's a risk that there will be maybe unintentionally, but agency capture in which only the largest companies can comply with all of the burdens associated with AI regulation. Certainly there's some suggestions that that's true also with GDPR and the privacy regulations. So we just have to be careful about regulations. You can certainly see in the Trump administration, part of the populism that we're seeing there is vigorous enforcement, but also trying to go with deregulation, especially when the deregulation is pushed by corporate lobbyists.
Right. I guess we've got some examples in our system where we lean more on a regulatory system, like the railroads, for example, which is one of the reasons why they have some different treatment under antitrust laws than they would otherwise.
Well, I mean, Elon Musk has a great analogy. He's obviously really pushing deregulation, but he says, I'm not saying we should not have referees
Right.
In a football game. We just don't need too many referees in the football game. We need the appropriate number of referees, and that's, I think, the appropriate analogy.
And clear standards, clear
And
rules
standards,
that
exactly.
they're applying.
Yep.
Ms. Cooley, in your role as the head of the NAG task force on antitrust, you worked with a lot of federal agencies on enforcement actions of different sorts. Both Senator Klobuchar and I in this meeting have talked about the antitrust, the Bipartisan State Antitrust Enforcement Venue Act earlier. We never could come up with a catchier acronym type title on that one, but it's a good bill. Are there additional tools that you think would help from your perspective, would help state attorneys general in their enforcement efforts to make those more effective and efficient? What could be done to enhance criminal antitrust enforcement efforts on a state level?
So criminal antitrust enforcement efforts on the state level, but also I would say that there's something that's really small that you could do to help merger enforcement, if I could. There is a proposed Uniform Law Commission proposal for HSR notice for states. And if that became a federal law rather than a piecemeal state law, it would be incredible, because really one of the things we hear about is that mergers take forever. And for states, when we're negotiating with the merging parties, right, I agree that if we want things to move faster, then we need to help them move faster, and not having states wait to get those HSR forms would be so great. Okay, so that's that.
How many different sets do you have on the state? Is there a bona fide patchwork quilt there? Differing standards. In other words, it's not as though they're all adopting the same model legislation, so you've got a lot of different material.
So there is a Uniform Law Commission recommendation. Some states have already started that patchwork. And so certainly some
They
states.
jumped the gun a little.
Well, you know,
Or just exercise their sovereign prerogative.
they're exercise, right? We do believe in state sovereignty in the states. So, yes.
Okay. Anything else you want to note on that? What we could do in addition to that? If not, I just didn't want to cut you off.
As for criminal enforcement, the thing you could do that would be the most effective would be make sure you fund the U.S. Department of Justice Antitrust Division and their criminal folks, making sure that it's boots on the ground. And I will say respectfully to my colleagues at the Department of Justice, boots on the ground, not managers, because we need the soldiers to help fight, because very often the state bid rigging enforcement works together with the U.S. Department of Justice.
So boots on the ground, not managers, translates to what?
I mean actual frontline litigators.
Okay, good. People who can do that. That makes sense. Can I ask one more question?
Yeah.
Okay. Professor Newman, can we talk just a little bit about the Obama-era resolution of the Ticketmaster issues? Why, in your opinion, did that not produce a more lasting, sustainable détente in this industry?
I used to teach that settlement as a bad example of what not to do in my antitrust class.
See, Mike had asked the question so nicely, and then he got an answer. See, it worked out that you liked.
Exactly.
Okay.
At its core, I mean, the problem is that you've left the inherent conflict of interest and the power in place. And a company like Ticketmaster, they're smart. They've got a lot of well-paid counsel telling them exactly how to try to find the ways around that order. And when they can't find a way around it, as we saw, they'll just try to break it, right? So in that case, that was one where the relatively far-reaching remedy of a structural separation early on could have prevented a lot of harms and not wasted so much government resources along the way.
So in other words, it was a structural remedy could have done it, but when it's conduct-specific remedies only that are adopted, then it's almost relegated to the facts of that case.
I think that's right. And you got to think about a company like this as wielding not just one lever, right? They've got a whole control panel in front of them. And if you're going to start trying to impose behavioral limitations on a company like that, it's going to end up, if mixing metaphors, in a game of whack-a-mole pretty quick.
Yes. That's when the sacred cows come home to roost.
Okay, that was a lot of mixed metaphors. Oh, you meant to do that deliberately. Very good, very good.
Thank you very much.
So, yeah, I love that image of them with a big control panel in front of them. My last question, following up on Ms. Cooley's, how she was able to talk about if she could, wave a wand, some things she liked, and boy, Mike Lee really geeked out on that idea there, so I'm sure he's interested in it. Anything you two would want to add on as we look at, remember, it's very difficult for us to pass things through some of our colleagues, but yet we've continued to persevere, and I do think some of our bills that Senator Grassley and I have done, that I've done with Senator Blumenthal, may end up as remedies in some of these cases, in addition to eventually passing. And so just if you could wave a wand on things you'd like to see us do besides have hearings and have you testify, what are some other ideas of things that you would like to see us get done? Professor Alford.
Well, I do think that you should try to find those points of agreement that could actually generate antitrust legislation. I think some of the antitrust legislation that you worked on, so hard in 2022 was so close. It was so close.
It was close. We got it.
It was really close.
I know. Thank you. I'm well aware.
I saw 16-3 votes out of committee.
Yeah, it was good that the bill, and then also we got our self-preferencing and the major
So the question is, of the various menus of legislation that were being proposed, which one has sufficient bipartisan support? Maybe it's yours, maybe it's Senator Lee's, maybe it's the Blackburn, Blumenthal, but something that could get pushed through.
Right, just to show that continuing momentum and actually make a difference, because not everything can be done with this new area unless we make some changes. Of course, I'd make more broader changes, as you know, but let's go on. Professor Newman.
Well, maybe one thing to add, if I could. We haven't talked a lot about the cost of rent, the cost of housing.
Right, and that work that we're doing that you were interested in as well, Senator Lee, that just the work that came out of our hearings on use of algorithms and what's been happening. I have legislation on that, and I think that's a ripe area.
That's exactly the area I was going to zero in on. I think judges are struggling when it comes to understanding that an agreement is an agreement, even if an algorithm is doing some of the work. And so clarifying the law really is how I would look at it for judges, would be very welcome.
Right. All right. Well, this couldn't have been more illuminating. I hope law professors watching at home will consider showing this great bipartisan show of force to their students. And for those interested, I think you see a united force here among many of us that will move forward and are going to be, yes, holding people accountable for things that have been said, but also trying to be supportive in terms of how we can continue to move this along. And I want to thank all of you so much. I also want to, again, thank my staff that is here, Dan and Ben and Phil, for their work, and also Senator Lee's staff, Senator Durbin's and Grassley's, our witnesses, and really everyone that's been working on this the last few years. And I'm looking forward, actually, to the continuation of these cases. And people have learned so much, that in the people on the committee, who are pretty smart anyway, the senators, but they have learned more the last few years than I think people predicted in terms of an understanding of what's going on. I think one of the reasons that we get caught up in this is often people say, oh, it's too complicated, I don't want to deal with this. I'm like, well, you know what? Our constituents are dealing with it every day in a not so good way. So it's incumbent on us to learn where those points of common ground are, how we can move ahead, and we are inspired to keep moving. So I want to thank you for your good work. Do you want to add anything, Mike?
No, just that it's a good point about keeping expectations low.
Oh,
Keep expectations low, then they're like, hey, the subcommittee's getting more.
No, I didn't say low. I sort of said high.
That's what I was thinking. Anyway, I agree completely. Thanks so much.
I don't know. I got to give you that gavel if you keep expectations high. Guess I have no control.
Thank you.
Anyway, okay. Well, thank you. I think we're going to keep the record open for 1 week until December 24th, 2024. I challenge staff to have their questions submitted on that day. That will be a lot of fun. So thank you. Happy holidays, everyone, and thank you for joining us. Thanks.